Hey guys, welcome to today's video. Buckle up, because the stars have truly aligned for this one. We're dealing with a rare hybrid, a full-blown Karen and a sovereign citizen, all wrapped into one courtroom spectacle. She fires her attorney on the spot, declares she'll represent herself, and then tries to tackle a probation violation hearing solo. This one goes off the rails fast, so let's get into it.
State versus Ashley Clark, 22 CR 216. Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
I got this myself has to be the legendary final phrase of every Karen who insists on leaving the house without protective headgear. She tosses out her attorney, who, by the way, had already negotiated a deal for her, throws that deal straight into the dumpster, and proudly decides she'll represent herself in a probation violation hearing. It's the kind of confidence only disaster can produce.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want to contest the hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir, thank you.
All right, Ms. Clark, any opening statement?
No.
I've got to admit, I love the confidence. Misplaced, reckless, and guaranteed to get her arrested, which is probably why it's so entertaining. She's charging straight into a legal brick wall, and she doesn't even see it coming. So now the prosecution calls the only witness they actually need, her probation officer. And trust me, that's where the real damage begins.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes.
And what was the result of that UA sample from Miss Clark?
It was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes. And I did. I received that. And apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
What is wrong with these people? The problem with sovereign citizens is that the gurus they follow only teach them one skill: how to fire their attorney. After that, they're completely alone because a successful sovereign citizen defense is still a mythical creature no one's ever seen in court. The moment they take responsibility for their own case, they end up steamrolling themselves into disaster, just like today's crash test dummy.
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
Oh, this is going to be good. So far, her entire legal strategy has consisted of not challenging a single piece of evidence the state presented and offering absolutely nothing in her own defense. So now we arrive at the closing argument, her final chance to show the court what she's got. And honestly, it's shaping up to be the perfect test to see just how many crayons she can cram into her mouth at once.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Where I come from, there's a saying, you're worried about the wrong thing, Karen. She's over here stressing about the IRS, but they're not the ones hauling her into court. It's the state of Kansas bringing these violations. She signed up to play a stupid game, and now it's time for all of us to see exactly what stupid prize she just earned.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA in the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
$1,200 a minute for every minute you're in jail? Let's do the math. 60 minutes in an hour, 24 hours in a day. Yeah, that's a whole lot of cheeseburgers, Karen. All right, guys, that wraps up the video. Turns out, having a public defender is far more effective at keeping you out of jail than firing your lawyer and doing absolutely nothing on your own. If you enjoyed the video, hit that like button. If you didn't, hit dislike. And don't forget to drop a comment below and subscribe with notifications on so you never miss any of my content.
I am a CIA agent on record with the United States of America, and I noticed some flaws in the paperwork. Where it says arrest date and time, it says at 3 a.m., but where it says time booked, it says midnight. How was I arrested after I was booked? That's a motion for dismissal.
Morning, Your Honor. Good to see you. As always, Robert Ellman with and on behalf of Mr. Greenwood. Mr. Greenwood, can you please state your name for the record?
The courtroom resets as defense counsel explains the real issue, a long-delayed competency exam that has stalled this case for months. The judge dives into the record, uncovering gaps and unanswered letters, creating a growing sense of confusion. This portion highlights how the system halts entirely when a critical evaluation gets stuck.
However, I am...
And your legal assessment of that is correct.
Thank you, Your Honor.
You're welcome.
And like I said, I was just appointed. I guess to me, as I could see in the Register of Actions, it looks like the competency exam was ordered back in potentially July.
It was ordered a while back, and there's issue with some records. So what I'm going to suggest is that you contact the Forensic Center and try to see if they need a new order. I don't think they do, given the January 7th letter that was sent. I think they just are waiting on something before they can complete the evaluation. So what I will do is I'll adjourn this to March 27th. If we get a report before then, we can of course move up the date.
Thank you, Your Honor.
Competency hearing March 27th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you, Your Honor. Have a good day, Mr. Greenwood. I'll talk to you soon. Have a great day, Your Honor.
All right, what are we doing?
Buckle up, guys. Today we're going to watch a courtroom moment shift instantly into chaos. Before the judge even settles in, the defendant claims he's a CIA agent and demands a dismissal because the paperwork shows he was booked before being arrested. It's the kind of opening that tells you this hearing is about to go sideways fast.
Daniel Lowell Greenwood.
We're still waiting on a competency.
That's my understanding, Your Honor. I have just been appointed to this matter just this week, but after speaking with Ms. Zenda, I do believe there is some kind of holdup with the competency evaluation.
Yeah, I have a January 7th letter that they're looking at for records. That's the last communication I have.
That's what the people have, Your Honor.
All right.
Can I speak, Your Honor? No?
Sure. Go for it.
I am a CIA agent on record with the United States of America, and I noticed some flaws in the paperwork. Where it says arrest date and time, it says at 3 a.m., but where it says time booked, it says midnight. How was I arrested after I was booked? That's a motion for dismissal. That's all I have to say, Your Honor. And I will be pushing for wrongful incarceration.
Pardon?
I will be pushing for wrongful incarceration of a federal agent.
Okay.
Your Honor, Mr. Greenwood did discuss these things with me. I did tell him that we needed to wait for the results of the competency exam before we could move forward on any of those issues.
Now we follow a young defendant admitting guilt to retail fraud. The judge walks her through every right she's giving up, making sure she understands the weight of her decision. It's a moment where the courtroom quiets down, focusing on clarity, accountability, and whether she truly wants to move forward with this guilty plea.
Your Honor, we're here for an arraignment and a pretrial. For purposes of the arraignment, we have received a copy of the misdemeanor complaint. We went over it. We would waive its formal reading. Ask that you enter a not guilty plea on her behalf.
And then having waived formal reading, pleading not guilty, court will enter that plea.
Your Honor, it's my understanding today the defendant is going to plead guilty under HIDA. She is 20 years old. So she qualifies for HIDA. And so
Hold for one moment. You got him. Thank you. All right, go ahead.
So it's my understanding she's going to plead guilty under HIDA today. She's 20 years old. She wants to proceed that.
That's accurate, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Go ahead and lower your hand. Say you spell your name out.
Olivia Ray, Olivia Ray.
All right. Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud under the Pittsfield Township Ordinance. Your understanding?
Yes.
All right, that is a misdemeanor, punishable by up to 90 days in jail and a $500 fine plus court costs. Do you understand that?
Yes.
And understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
I'm sorry, can you repeat that?
You signed an advice of rights form,
Yes.
is that correct?
Yes.
All right. Do you have any question regarding any of the rights on that form?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium.
The judge tries to bring structure back, setting a new date for the competency hearing and pushing the case forward. But before there's time to breathe, we shift sharply into a brand new arraignment. It's a complete tone change as the next defendant enters the spotlight, and you can feel the courtroom settling for a very different kind of case.
Those are your rights which are part of the trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today that you plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily,
Yes.
of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
I make it plain again. On the date of March 29th, 2025, at the location of 2000 Waters Road, what do you do at the Target store that makes you think that you're guilty?
I walked in and I exited with a face wash without paying for it.
With what?
A face wash.
Face wash?
Mhm.
Okay. Store is open to the public at the time?
Yes.
You didn't have anybody's permission to take that property, did you?
No.
This property you took was offered for sale by Target?
Yes.
All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor, we're satisfied.
All right, court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter,
June 25th at 9 a.m.
That works.
June 25th, 2025, 9 a.m. You haven't appeared before me, obviously, before. Are you in school?
Not at the moment.
But yes,
Well,
normally.
yes.
She just finished her
Sorry,
second.
it's the summer.
Here the judge presses for details, and the defendant explains exactly what happened. Entering a Target store, picking up a simple face wash, and walking out without paying. The judge confirms intent, access, authorization, and value, ensuring every element of the crime is clearly established. It's a precise breakdown of how a small decision becomes a legal consequence.
Your Honor, she's a second-year student at Michigan.
At Michigan? University of?
Mhm.
Sorry, you went to a second-rate school. It's okay, I'm a Maryland grad, so I have to just say that. All right. Go ahead, you were saying that. So
That's really it. We were going to ask for a personal bond, Your Honor. She's 20 years old. She is a full-time student. She's clearly off for the summer. She is taking this very seriously. Her parents were, her mom's here right now. Her dad was here this morning. We were mixed up on the time, but he was here and had to take off. But he did take off work and he was here. She has taken a extensive theft awareness course. She took a 16-hour course. I presented Mr. Seiler with a copy of that. So based on that, I would ask for a personal bond. And then I got to notify you of one thing. Oh, actually, she has never mind. We'll be back before that. She has a wedding. Her uncle's getting married in Wisconsin, but that's going to be July 2nd. So we were going to ask for permission to leave the state for that.
What are you studying?
I'm an acting major.
Did you graduate high school here?
The conversation shifts toward sentencing preparation and personal background. Her attorney explains she's a college student. Her parents are involved, and she's already completed a theft awareness course. The judge mixes professionalism and humor, lightening the tension for a moment before addressing travel requests and upcoming obligations.